We start? Yes, still talking. Stop. Thank you. Oh, welcome. Hope I'm in a nice couple. Your midterm's on Tuesday. A guaranteed way to fail, 100% is don't show up. Every year, one person doesn't show up. Don't show up late. And I mean this. If you come here late, you won't be allowed to take the exam. This is practice for real exam. If on a final exam you show up late, they're not going to let you in. Why? It's a distraction. It's a distraction. People are focusing on the exam. Someone comes in, makes a commotion, puts your books down. So do not come in late. Please, just don't do it. Class starts at 10:40. Get here at 9. Study for an hour. But without fail, every year I get these frantic emails. There's an accident in the HOV lane. The bus broke down. I get all these emails. Car accident. Maybe they're true, maybe they're not. I don't know. Don't be late. Okay? By now, you should have already taken your practice midterm. You should have a sense of where you are. You're going to take the actual one on Tuesday. Okay? At some point after Tuesday, I'll email around a link that you can sign up for sessions. There'll be over 100 slots between now and the end of the term, so there's definitely going to be something for one of you to pick. All right? Any questions in your mind? And by the way, I won't be there. I'll be proctoring it. I think either one of my research assistants or Cindy, my secretary, will be proctoring, but someone will be there in my stead.
I have a quick question. For exam solving, can you do a word count?
Yes. There's a feature in word count. It's under stats. Not character count, word count.
Right.
And if you don't know how to do it, go to the registrar today and ask them. They'll show you how to do it. I don't want you to have to figure it out on the fly. If for whatever reason you can't figure it out on the day of, you use your finger. It works really well. And actually, to count to 1,000 doesn't take very long. It actually takes less than a minute. It's a fairly quick process. Do not give me characters. Don't give me 1,000 characters. That's like 4 tweets. I don't want that. You will not get much more than a D. I mean, actually, you could probably pull a D because you actually showed up. But that's about all you can get. Anything else in your mind?
It's not. I'm sorry.
Yeah.
It's not graded so much as if we don't try.
No, it's not graded. I'll give you a grade A, B, C, D, but it won't count for anything. You understand?
Yeah.
I wish I could actually grade you on this for real. Like, in my perfect world, your midterm would be worth maybe 10% of your final score. I can't do that. I'm not allowed to. The school's handbook puts fairly strict rules of how 1L classes are graded. And even though this is property 2, right, it's still considered a 1L class. So yeah, I guess right? But if I actually made this worth 10%, people will try much harder. I know it. I know people don't take it as seriously as they should, but I do the best I can with the school gives me. All right, any other questions? Yeah.
So is it going to be like 1 fact pattern and 5 questions?
Exactly as it was last year and the year before. Exactly, the exact same format.
So if we tell it, we're not going to reduce our grade?
No, I do.
Oh,
I do. If you don't show up, what I can do, and I haven't done this in a couple of years, people tend to actually take it seriously, is I can reduce your participation score by 1/3. Right, so if you get a B+, it's a B. I haven't done this in a while, because generally people show up and give me a modest amount of effort. You simply just blow it off and don't show up, or you show up and leave it blank, that's what's going to happen. That I can do. I didn't mention this before, though, but Hamilton, I mentioned this, right? So, you all heard of the Broadway show Hamilton, right? Okay, I have 4 tickets for the show when it comes to Houston. I'm a subscriber. So the highest score in the midterm gets a ticket. Whoa. So I have 4 tickets. The highest score my midterm for common law, this semester for property, and the next term the same property common law. The show's I think in March or April. So it's in the spring. So I'll give you the ticket in advance. I already have them. They're at home. So the highest score on the midterm gets to Hamilton. There's only one high score. I make sure there's only one high score. So occasionally people tie. It happens every now and then. It drives me crazy because I grade it randomly in a great amount of order. But occasionally when you add up, people tie. So it happens. So there's your incentive. It's an amazing show. I saw it on Broadway in I think it was January of 2017, before it became humongous. I was able to get tickets for the original production. But it's a good show. I can't believe I didn't mention it. I'm so sorry. Anyway, I'm glad you reminded me. So, any other questions? Yes, ma'am.
I thought you said you should have already gotten an email by today, about downloading it.
They said, I got the email already, they said it'll happen today. If we don't get by tomorrow, then bother me, okay? They emailed me yesterday saying that, they've already set it up, so you check. What the way it works is with ExamSoft, they're gonna give you a number. This is not your G number, your G whatever, 00 whatever, it's a specific midterm number. This will be different than your number for the final exam. Do not use your number from last semester. And I'm going to say this, you're going to laugh. Don't make up a number. Every semester, a couple students don't have their number with them, so they make a number up. That makes it impossible for me to grade your paper because I don't know who you are, right? One person, though, fortunately, made up a number that was his birthday. And the registrar actually was able to figure out who the person was. So use the number. If you don't have a number by tomorrow, go to the registrar, they'll help you out, okay? I don't see your name when I'm grading it, but after I do the math, I then go back and I check to make your appointments. Right, so if you don't tell me who you are, I can't help you. So don't make up a number. It's like, oh, if I make up a number, you can't fail me. No, that's not the right attitude. I want to help you. This is not about hurting you. This is about making sure we identify any problems halfway through the semester, and hopefully we can fix them and correct them. And often we can. Sometimes it's something we can repair, but not always. Anyone else? Other questions? Anything else? And by the way, everything up till class today is fair game for the exam. Okay? So make sure you pay attention today. And I haven't read the question yet. I do this deliberately where I only write the question after my last class so I inadvertently give it away. Because usually it's like, oh, I have this great idea, I'll talk about it. So I don't know what your question is yet. I'll write this weekend. I think probably a full day to write it. I'll write this weekend, and so I can't get my hat today. I always write the final exam question after the last day of the semester. All right, anything else? Okay, let's do a question. So I put this one up for 4. Okay. Here's your question. Okay. Adam owns Blackacre and Whiteacre. Okay. Adam sells Blackacre to Betsy, but Adam reserves an easement that allows the owner of Whiteacre to cross over Blackacre. Okay. Then Betsy buys Whiteacre and sells it to Carl. Carl can cross Blackacre. True? False? Go ahead. Just a couple more seconds. Alright, let's stop it here. Okay, where did I drop off last time? Who's next?
I think it was me.
Matt, you next?
The person that was next not here, I don't think.
So
Thanks,
Matt
man.
and Christine, is that right?
I guess, I don't know. I'm pretty
Okay,
sure
that's fine, I'll start there. Thank you. Matt, what'd you put here?
I put true.
You said true, okay. So walk me through your thinking, right? I just want to give you the bottom line. How'd you get to your answer?
So I basically looked at the intent of the reserved easement. It would seem that by reserving the easement.
Well, first of all, what kind of easement was created here? How would we characterize the easement that Adam reserved?
I would say it's an appurtenant easement.
Good, it's an easement appertenant. Why do you think it's an easement appertenant?
Kind of going along with the intent. The wording makes it seem like it might be just to a person, so it'd be engrossed, but that doesn't make sense because if he sells the land, then the land be
Well,
landlocked.
what's the wording? How do I describe it?
The owner
Of?
that word of Whiteacre,
Now, does that refer to a specific person or whoever the owner happens to be?
whoever the owner happens to
Ah, everyone see that, right? So you think it's an easement appertenant, right?
be. Yes.
Okay, good. So if that's an easement appertenant, you think Carl can benefit from it?
Yes.
Why do you think Carl can benefit from it?
Because he is the owner of Whiteacre. Now,
Okay, good. All right, Christine, what would you put?
I put A.
You put true, okay, and just walk me through your reasoning.
basically the same thing. I thought it was the after tenant because the intent was for whoever owned Whiteacre.
Good. Now, Christine, let me ask you a follow-up. What's the effect of Betsy buying Whiteacre in the middle? I put that in the question for a reason. It wasn't just random. What's the effect of Betsy buying Whiteacre there? Well, think about it this way. If Betsy buys Whiteacre, does she need an easement to cross over Whiteacre? So what happens to the easement there?
Transfers.
Amy, what do you think?
I put false because I feel like I read something in today's reading that said that if the parcels are owned by one owner, that the easement goes away.
She's right. She's right. It's false. Whoa. Some people do their reading carefully, right? If the same person owns the dominant and the servient tenement, right? The servient tenement there is Whiteacre. The dominant tenement is Blackacre. If the same person owns both the dominant and the servient tenement, the easement's extinguished. So by the time it gets to Carl, C, right? There's no more easement left. So he's not able to traverse the property. Yeah. Yep, the back. Did you put your hand up?
Yeah, that's my question now.
Okay, that's good. Did everyone see that? You need to think carefully about these. This is the exact sort of thing if we try to throw up, 80% of the class, right? You need to say first, is it easement gross or appertent, right? That's your first step. Then you say, okay, which one's dominant and which is servient? We know that servient is Whiteacre, dominant is Blackacre. Okay? But then you got to read the question. Don't just jump to the end of the conclusion. You see that it's transferred to the same person, Betsy. Betsy has both of them. Easement disappears. Does everyone see why? Right? There's a question asked Christine. Would Betsy need an easement to cross her own property? Of course not. It makes no sense. Right? It's hers. So you just extinguish the easement, right? It goes away when it's held in the same person. So then when Betsy sells it off to C, there's no more easement. And then there's a trespass. And he tries to cross over Whiteacre. Everyone see that? Alright? So yeah, read. This was my exam for you, right? Read the question really carefully, right? I will trick you, but not by tricking you, right? I will put stuff in the question, and every word I put in the question is done deliberately to give you some other piece of information. Don't just assume it's a useless piece of knowledge. I'm not here trying to give you a lesson. I'm giving you specific bits to try to lead you one way or the other. So yeah. All right. So for those 10 of you who put false, I appreciate that you got that. Yeah, Chester.
And Blackacre is serving, right? And Whiteacre is dominant.
Well, you can cross over Whiteacre. I'm sorry, you can. Did I say it wrong? Yeah.
Blackacre.
I'm sorry. So you cross over Blackacre. Blackacre is a servient one, and the Whiteacre is dominant. I reversed it. I'm sorry. Thank you. Always correct me. It's a mental hang-up where I flip things in my head, where I say the opposite of what I mean. It's the damnedest thing. It's a bizarre trait. I do it all the time. So because you're crossing over Blackacre, that is one that's doing the serving. That's the servient, and then Whiteacre is the other one, which is the dominant interest. So is that the same point?
Oh, no. Even if it's an easement by necessity where he has no other access to that property but through the easement he has through.
Well, that's for an implied easement, right? That's a different story. Here, right? Here, let's say there are two pieces of land, right? To your question, and one that had easement by necessity, and then both pieces are owned by the same party. That easement by necessity disappears. But if it's sold to a third party, you re-imply easement by necessity. It's a new easement by necessity.
So, I mean, that would be a good thing if you own a property that you have an easement on and you're not happy about it.
Buy
if
it.
that property goes, you just buy
Exactly.
it and sell it back off. And now
Exactly.
it's an easement.
Exactly. Yeah.
Okay.
Yeah. I mean, and the reason why is you have the same person holding both the dominant and serving the state, and so it just wipes it out. That's exactly how you do it. Yeah, Matt.
It may not matter, but what's the proper terminology for when the easement dissolves, goes away, terminates?
Terminates is good.
Okay.
Yeah. I mean, the technical term is when it's held by both the dominant and the servient estate owner, it has no effect. So terminate, I guess, is a fine word. Yes, Lauren?
So in that case, in this case where it goes away with easement, when the next person comes along to buy, shouldn't the easement be implied?
Well, they can ask for an implied easement, but this was not implied. This was specifically reserved.
Right, I know in this case, but when it's
Well,
still,
if there's a claim for implication, right? But there's nothing in the facts to suggest that an easement is necessary for fairness, right? If it's landlocked, maybe this is a justice question, but the way I wrote the question, there's no reason why there has to be one. Make sense? Yes, sir, Bradley.
So the dominant right is the one that benefits from.
Yeah, and I flipped it. I flipped in my head, right? So because they're crossing the Whiteacre servient and Blackacre's dominant.
Okay. So Blackacre is allowed to
Crossover. Yes, exactly right. Someone else in this question? Good. All right. Well, 80% of you got that wrong, so which is more than I expected. I thought it'd be a half and half. So study hard this weekend, please. All right. Let's start then for today. I'll turn this topic off. The topic for today continues easements and focuses on how easements are assigned. Now, generally, when you have an easement appurtenant, it stays with the land. And the reason why is obvious. Consider this example. An easement that allows the owner of Whiteacre to cross over Blackacre. It doesn't give a name, it doesn't say Adam, right? It says the owner of Whiteacre. That is a relative term. Whoever happens to be the owner at any given point in time, that is whom is benefited. In fact, that's how you know if it's engrossed or appurtenant. If there's a name, it says, reserves an easement that allows Adam to cross, right? If there's a name there, then it's engrossed. If there's no name there, it's a name of a property, it's an appurtenant easement. Okay? So there's no problem with easement appurtenance transferring from one owner to the next. Historically, there were some problems with transferring easement and gross, although the modern trend seems to be those are allowed. Okay? All right, so any questions before we get started? All right, the first case is a little bit tricky. It's the Miller versus Lutheran Conference and Camp Association. And this involves the Lake Naomi Club in the Poconos. The Poconos is a region of Pennsylvania that's fairly close to New York and New Jersey. And it's a very popular vacation resort, at least was back in the day, but still is today. And I have some pictures of it. You can see people here boating and going around the water. Now, I'm going to say this only because it has to be said. Bathing means swimming. Every year, without fail, someone says, "Ew, that's gross, we're taking a bath in the lake." No. Bathing means swimming. Understood. The second thing is, when water freezes, it becomes ice. And yes, you can get ice from the same place where you bathe or swim. Because what one student said was like, "Ew, that's gross, we're making ice from bath water." Like, you see, right? And so I make that disclosure to avoid the EU moment. It's fine. It's a clean lake. In the winter, it gets very cold in Pennsylvania. The water freezes, and before refrigeration was widely spread, the way you made ice was by having a frozen lake and chipping up, and it would keep it in storage during the year. Okay? Good. Well, we got that out of the way. Yeah, one year, it's like, "Oh, that's gross. We're taking a bath and making ice out of it." Like, no, they're bathing. But by the way, you should know though, in a lake where there's boats going around, it may be dangerous to swim, right? Because the oar, you can get knocked out, go swimming underneath, and get hit by whatever canoe. So there are potential problems with both swimming in a lake that has boats going around. Also fishing too. If people are throwing lines into the water and you're swimming, you could get hurt. All right, so let's try to figure out the timeline. I think, Mark, you're next. The timeline here is a little bit complicated, so we can walk through this. What happened here? What was going on?
So, I might be a little wrong here, but I believe Frank Miller and his brother started a company called the Ponoke Spring Water Ice Company that created a dam to make the Naomi Lake.
Okay.
And then I believe it foreclosed, and Frank Miller actually bought from the company. He went and grabbed it and actually got the rights to fish and boat in the lake, and then transferred 1/4 of those rights over to his brother Rufus. But he actually gave his brother, I believe, swimming rights as well, bathing rights as well. So he didn't own those rights based on the original easement or deed that he got. And then they operated boating and bathing houses on the lake until 1925 when Rufus died. And then Rufus's estate sold it to the Lutheran Church, and Miller, or Frank's wife, I believe at the time, sued because they didn't have the rights to use it for bathing.
Okay. All right. So that's more or less right. Let me walk through the timeline here because it's actually somewhat confusing and makes a big difference. So in 1895, Frank and Rufus leased the land for 99 years to this company, the Pocono Spring Water Ice Company. Okay. Now, what does that mean, right? This was their own company, but they were trying to transfer it from private ownership to the corporate identity. And the reason why is that usually when a corporation does stuff and they screw up, the liability doesn't go back to the original owners, right? So if you want to own property, you probably aren't going to keep it in your own name. You'll put it in the name of the corporation. But rather than leasing it, they give rather than selling it, they give a 99-year lease, which of course is beyond their own lifetimes. In fact, 99 years from 1895 should be running out. I guess 20 years ago. I don't know what happened, but that lease eventually did run out. Immediately, or a couple of years afterwards, the Pocono Springs Company put a mortgage on it, right? Basically to get money and capital. And then the following year, the company gave Frank the right to fish and boat in the lake. Here's an important point. In 1899, this company gave Frank the right to fish and boat. There was no mention of bathing. That is, there was no mention of swimming. Right? So at that moment, right, David, at that very moment, did Frank have the right to allow people to swim in the lake at that very moment? In 1899. The answer is no. Okay? When you get an interest in property, you only have the interest that's given to you. So if you're given the right to a fish and to boat, that's it. If you allow swimming in the lake, you're trespassing. You say, well, what difference does it make, right? The interests are specifically defined, and we generally try to obey the intent of the parties. Now, why did the grant not mention swimming? He probably forgot, careless, sloppy, probably wasn't deliberate. Because, as I understand it, this corporation was basically just a bunch of family members, right? They were all on the same team. So I don't think this was deliberate, but whatever, they didn't do it. Okay, then the following year, 1900, Frank gives Rufus an interest of 1/4, right? So that means Frank has 3/4, 75%, and Rufus has 1/4, 25%. But the conveyance here has different language. It includes fishing, boating, and also swimming, bathing. Okay? Now, David, I'll come to you again. Did Frank have the ability to convey to Rufus any interest whatsoever in swimming?
No.
Why not?
Because he didn't receive.
Exactly, right? Frank had no power to convey an interest in swimming, but he did anyway. And again, this is common stuff, right? I'm telling you, in the exam, people are going to sell stuff they don't own. I promise you 100%. Now, why? Again, Frank wasn't like a lawyer. He probably didn't really know. Of course I have an interest in the lake. I can let people swim in it. It wasn't even an issue. But that doesn't end it. Did I call you guys last time?
No.
Okay, I'll come to you now. No, you're honest. I appreciate honesty. Don't lie, because eventually I'll find out. It's like, oh, you called me right. It's like, it's like your mom asked, you did the dishes? Oh, I did the dishes last night, Mom. Right? No, you didn't. That's fine. He's yelling at you. Okay, take it outside. So The problem is then for the next 25 years, right? Frank and Rufus operated a business which allowed swimming. So I think David's right that 1899 or 1900, they didn't have the right to allow swimming. But what after 25 years? What happens then?
It would be prescriptive
Yes, exactly. Why prescriptive?
because was it allowed? Like it just kept going?
Well, who are they squatting against though? That's an important point. Who actually had the right of bathing at that time?
The corporation.
Yes, exactly. She's right. It was the corporation, this Pocono Springs Company, right, that had the right to bathe. And throughout this entire time, Rufus and Frank were allowing swimming to go on. This was open, notorious, continuous for 25 years. Again, it wasn't year-round. It's very cold in Pennsylvania in the winter. If you try swimming there, you'll freeze into a block of ice. But in the course of how this land is used, which is a summer vacation home, it was continuous swimming for 25 years. Okay? All right. So that's the easy part. We already did adverse possession. So we know that they acquired it. Right? But then the case gets a little funky. There's a foreclosure of the mortgage. Let me talk about foreclosures. So I guess this business didn't do very well. And the interest was sold to this other company, the Pocono Pines, whatever company. Similar name, but different company. Okay? Rufus then dies in 1925. And then this Pocono Pines company, which again bought at the foreclosure sale, is vested in Catherine Miller, who was Frank's wife. So here we have the situation that for all these years, right, the squatting was going on, and they obtained a prescriptive right. So when Frank and Rufus died, collectively, they held the right of bathing, that is, swimming, in this lake. Right? When they died, between the two of them, they collectively owned the right to swim and allow swimming in this lake. But the question is this. Rufus tried by himself. Actually, it was Rufus's executor. But Rufus's executor tried to give a license to the Lutherans to bathe. Now, there was a note on this in the case book, but the Millers didn't like the Lutherans very much. And there was some religions never get along, but there's some dispute between the various churches. But whatever, it doesn't matter. But the question is this. Could Rufus's estate convey unilaterally an interest in bathing? Right? Now, if it was a specific easement for boating and fishing, that's not the problem. That was given by grant. That's not an issue. You got a 1/4 interest there. So Rufus could convey his 1/4 interest in a boating and fishing. But the question for essay is this. Can Rufus's estate convey interest in bathing that was acquired through prescription?
I think the court says that they can.
Can or can't?
Can.
Well, why do you say that?
Because you said that the way they carried the business was systematically and commercially, and it wasn't for personal enjoyment, but for personal use.
But what about Frank? Why doesn't his estate have any say in this? Didn't they acquire it together? Frank and Rufus acquired it by running the business together for a 1/4 century, right? How can Rufus do it all by himself unilaterally?
I'm not sure.
So let's break it into two questions, right? In theory, can an easement and gross be assigned? That's it. It's just in theory, not this case. In general, can an easement and gross acquired through prescription be assigned?
Yes.
Okay, it can. Right. So the first rule of this case, which I think is the modern trend, is that easements and gross can be assigned. And I think that essay said the issue correctly. It's the commercial nature of character, right? It's a commercial transaction. And there's no reason to deny the parties' intents. Okay? So an easement and gross can be assigned. But that's not the end of the story, right? So Nicole, why can't this particular easement and gross be assigned? What's the problem here?
say that would be one stock.
Yes, very good.
So, since Frank didn't consent to, the granting of the license?
He's dead though.
Yeah,
So who would have to consent?
the heirs.
Exactly. Okay, so everyone see that. The court has this one stock rule, right? This one stock rule. What does that mean? If two people acquire an easement through prescription together, by running this business together, it can only be sold together. Right? This is not like tacking and privity, but it's a specific rule for easements that the way they're acquired must be how they're sold. Because indeed in this case, right? In this case, Rufus's estate and Frank's estate didn't agree. They did not get along. They hated each other, it seems, right? And they did not agree how this easement should be used. So what if Rufus decides to let the Lutherans swim here, and Frank says let the Mormons swim here, and then all these different religious groups start fighting in the water. It's a bad thing. So the court applies this one stock rule to say that the easements in gross can be assigned, but the easements that were obtained through prescription cannot be assigned. Right? So it's a weird thing where the easements regarding boating and fishing can be assigned, but the easement regarding the bathing cannot be assigned. What does that mean? Well, the Lutherans can boat, they can fish, but they can't swim. Strange, right? But that's the effect of this case. Rufus can convey the easements he got that were assigned, but not the ones obtained through prescription. So as a matter of course, though, right, it means no one's going to take this easement at all, right? Why? Because if someone falls out of the boat, yeah, exactly. Who said it? Yeah. If you fall out of the boat, you start trespassing, right? If you're trying to fish and you slip off the pier, you're trespassing, right? If some kid wanders into the lake from the shore, he's trespassing. So effectively, this is not going to work. So even though Rufus could convey his 1/4 interest, which doesn't really count for much, in the boating and the fishing, it's basically worthless without the bathing component of it. So I don't know exactly what happened in the aftermath of this, but if I had to guess, they figured out a way to pay for the bathing rights. Yes, Jesse?
So a prescriptive easement can be assigned, it just has to be the whole...
This is the Pennsylvania rule, and I don't know how widespread this is, but the rule does make sense, because if you acquired it together, it should be distributed together. I think there's a good fairness element to that as well. But I think the problem here specifically is, if you just have the fishing and the boating by itself without the bathing rights, the lake is basically useless. Yes, sir?
So, I'm trying to figure out what's different than wasn't lake.
Yeah, exactly. It's a very unique question because of the nature of water, that you do multiple things. But I don't know. I'll give you an example, right? Let's say you have an easement to ride a trail with horseback, right? But you don't have it to drive it with cars. Let's say it was an old easement that you can ride this with horses. If you can only convey the right to ride by horses, then people can't drive their cars there. So maybe you can still use it for a horse trail, but not for a car trail. That's the example I made up. Maybe a better one. I don't know. But the idea is, when you have an easement, it's not to use it however you want. It's to use it in a very specific manner of where you come from and how you approach it. Anthony?
Yeah. So, are prescriptive easements assignable? If you're in your land and you walk,
they are. So the court says here you can assign a prescriptive easement, but they have this one stock rule. So if you're going to be a squatter, do it by yourself. Robert.
On the whole
Yeah, exactly.
So, sorry, the prescriptive easement would continue to exist even after Frank Miller and Rufus died, if they both assigned it to their heirs and it kept going. It would keep going.
Yeah, because once you gain something by prescription, it's yours, right? It's basically the owner no longer has fee simple. It's you're actually putting like a mark on their fee simple.
Robert, so if the issue wasn't over swimming but rather boating instead,
both of them had an easement of gross, so do you need the consent of both?
Well, what was Rufus's interest in the voting though? What percentage?
1/4.
So what does it mean to convey 1/4 interest in voting? What would that actually mean as a practical matter? You can swim in, you can vote in a quarter of the lake? No, it was actually a quarter of the profits from voting. So again, it's very hard to convey a fractional easement, right? What would the Lutherans do with that? I mean, I don't know what they would even do with that. Because then they'd have to give 75% of profits to Frank's family, I suppose. But he may not want it. He may say, I don't want voting, and that may veto the entire project. That's why fractional easements in this case create a lot of issues. So you can convey it, but I don't think anyone would want to buy it. Yeah, Jesse.
When it comes to access, does it work like kind of like a tenancy in common, like even if you?
No, it's not. I'm so glad I said it. It's not like a tenancy in common. There's a note on this after the case. They're not treated as tenancy in common because the easement was for a percentage of the revenues, right? With a tenancy in common, there's no rent, there's no money being changed.
Not.
What?
I was thinking concerning usage. It's an easement to use something, and you have a quarter of that interest.
Don't think of it as a tenancy in common. I know you want to. I'm glad you remember for property one, but they're not considered the same way. These are business transactions where specifically you're going to be splitting profits, whereas the tenancy in common, there's no rent between the parties.
This isn't about usage at all.
I don't think so. Yeah.
Once this lease is over, all this is void anyway, right? All these disputes are now over because the lease is up.
Oh yeah, 99 years lease. Okay, so your question is, if you have an easement on a piece of property that's leased, when the lease ends, does the easement go away? I don't think it does. I think the person who gets it back after the lease, the true owner, is now subject to this easement. You guys think about it this way, right? When they were squatting for 25 years, who were they squatting on? The corporation, right? But who was the actual superior owner? Catherine, who was also aware, right? So if you own property that's being leased and there's a squatter, you should be aware as a landlord and the person who's a tenant that there's a squatting going on. So you're actually, I think the easement would survive the 99-year lease. But what I suspect happened is after this this entire fight, the Lutherans just paid off and said, "Give us everything," and they found a price they wanted to pay. This lawsuit, at least in my mind, screams of these brothers hated each other, or at least their in-laws hated each other, and they decided to litigate this. Yeah, Chester.
So we did say that an easement, if the prescriptive right can be transferred, but the one-stop is
Yes, but so in theory, a prescriptive easement can be transferred, but in this Pennsylvania regime, this one-stop rule, all the parties must turn their keys at the same time. They can't do unilaterally. And I really think that makes sense. I think it's actually a good rule. Because they squatted together, you know, they did this deed together. It's not privity, but it's similar to privity, same kind of idea. Right? I mean, we didn't do this with adverse possession, but what if you had two squatters, right? Remember Mr. Robinson the first day of class, right, in Dallas? What if Mr. Robinson and his wife, Mrs. Robinson, were there, and they squatted together? He was there Monday through Friday, she was there on the weekends, right? And together they got 10 years collectively. And then after 10 years they got it, and then Mr. Robinson says, "Okay, it's mine now, I'm going to sell it myself." She's like, no, I'm going to sell it too. So I think that the rule does make some sense, this one stock rule. All right, so the bottom line here is easements and gross can be assigned. Prescriptive easements can be assigned. However, with this one-stop rule, all the parties have to agree to convey prescriptive easement.
So in this case, one party only has 25% of the
Profit, yeah,
profit,
proceeds.
right? So for easement and gross, how do you determine what portion?
It's a weird idea because it's not. This was Jesse's question. Where it's going. It's not saying that he owns 25% of the lake. It's saying he owns 25% of the profit derived from swimming in the lake, right? The easement is actually allowing the usage of swimming in this region, and as a consequence of that, 25% of the payment thereof. But the easement isn't really concerned with the money. It's concerned with the right to swim in that area. But the money does complicate the question.
Well, I mean, I guess my question is, if you're assigning it because you have a gross easement, how do you dictate?
Well, it's a partial easement. You can split an easement up among the corporation, right? You can say that the easement's assigned 50% to this corporation, 50% to that corporation. They both have the right to use it and benefit from it. Right? The purpose of an easement is to benefit either a piece of land, if it's tenant, or benefit a party, if it's gross. This benefits a person, so it's gross, and they're making money off the easement. But I see your question, Lauren. It's not saying that Rufus can cross over Blackgate here. It's in Rufus can run a business that people profit on, as he makes money from that. But that's what the easement's actually allowing. You're allowing him to basically run a business on someone else's property, because neither Rufus nor Frank owned it. It was owned by this other company. Make sense? So other questions on the first case? Yes.
So one stop rule is that common law for example?
I think so. Yeah. I think it's a common law rule. Other questions? Other questions? Okay. All right, so the second case, Brown versus Voss. This is another case from the Hood Canal, which is in Washington. You may recall one of our first cases of the year, Howard versus Punto, was from the same region. This is where we had adverse possession because everyone's lot was like 50 feet over where it was supposed to be. Remember this case? So this was apparently a place where surveying does not go very well, and people don't really know or care where their actual property is. So, Casey, you want to give me the facts, please, in the second case?
So the Voss family owns lot A,
Uh-huh.
and the Browns get lot B.
Good.
And there's an express easement leading like a private road across lot A to go to lot B. But there's already a house on lot B and they want to tear it down, and then a new house across lot B and C. And the businesses don't like that they are using it for another piece of land also, and they like barricade the
Oh, they did, yeah. So a general rule of thumb in property, if you ever build a fence to block someone, you're going to lose. I don't know why, but in all the cases I've read where someone takes self-help, right, they put up like a fence or a cement cable, they put logs, right, they put down logs in the road, whatever they did here, right, you're going to lose. Even if the law's on your side, you're going to lose. That's exactly what happened here. So this case raises the question of the scope of an easement. So here we have the facts, right? Now, they describe lots B and C as landlocked. Okay? There's a note on this after the case. They weren't. Lots B and C had direct access to the main road. Everyone see that on the map, right? So, I don't know if anyone ever actually looked at a map back then. I mean, Google maybe didn't exist, I don't know. But this case is very strange because B and C could have easily gone to the main road by digging a little ditch, I don't know. I mean, they were able to get to the main road. That wasn't a problem. But for whatever reason, we have the facts here. Right? So originally, you have A, B, and C. I like this map. It's a little bit easier to read. Okay? There was an easement that allowed the owner of B to travel across A and see access here to the main road. Okay? There was nothing about C when the easement was originally drafted. But then the plaintiff wants to build a house that straddles the border between B and C. Okay? Now, I'm going to be very, very pedantic here, right? Antonella, what if, the plaintiff just built his garage on lot number B? Letter B, right? He built his garage on lot B and never bothered bringing his car into C. Would there be any problem there? He built his house for sure straddled the lot, there's no question, right? But he put his garage or his car in his driveway on lot B and never. Would there be a problem there? Why is this case even a problem, right? Why didn't he just keep his car on B?
It was a problem because if he was ever, if his house was on C, and then so he was on C and he would use like the easement.
But why does he need to use the easement? His car is not driving on C. I mean, the question I gave you, why can't he put his garage on B?
It's just the way that it's, like, if it's granted for a specific purpose, it has to stick to that
But why isn't that part of the purpose if the garage is on B? The easement has nothing to do with where you live. The easement concerns where you travel, right?
I guess it's where you're traveling from.
Again, the garage is on B.
But if he owns.
Oh, so he woke up on C, right? His bedroom's on C, and he walked from C to B, and then got in his car and went from B to A. That's the problem.
I'm assuming.
Right. So this is it's a weird case, and I don't think the opinion actually discusses. This occurs when I read the decision. It's like, why does it matter where the house is? The easement concerns traveling, right? The easement concerns transportation. And why couldn't you just argue, we're only traveling from B to C? The fact that I own 2 pieces of land, but maybe there's a question, Antonella, he woke up in C, his bedroom was in C, had a shower, had a coffee, walked to his car, and then crossed it. So maybe that's the reason, right? Maybe it doesn't have to do with his car, maybe where by foot. Lauren, help us.
I think it's because, like in last class, you mentioned that even though one person owns both lots, it's still 2 separate lots. So if you're giving that owner who owns both B and C easement over A, then now you're giving lot C the easement.
So you're saying because he owns both of them, it's not where he wakes up.
Right.
Oh, Stormy, you want to add something?
Maybe I read this incorrectly, but I thought he wanted to extend the easement to C, and that's what the problem.
Well, I'm saying, forgetting that, why, I'm giving you a different one, right? Why can't he just build his garage on B and make his life easier? Right? Why do you have to be a jerk and build his garage into C? Right? I think Lauren's right, but I'm giving like a slightly different question. But if you're actually trying to extend the easement, then there's a problem, right? So, in other words, had you talked to a lawyer first instead of an architect, it's probably been a better case, right? Because he probably built the blueprint for this new home without doing his homework, or didn't even care. So this entire case could have been avoided by simply making the garage and B, telling the judge, look, I'm not trying to change the easement, it's doing exactly what it is before. That's not so hand. Yeah.
Could he have been trying to get a prescriptive easement on his own property?
Well, that's not a very smart thing to do.
Well, if he travels over B every day to C
No,
for 10
on
years?
his own property? No, you can't squat on yourself. you can't prescribe on yourself. No, it doesn't work.
Could he grant himself the easement from B to C?
Well, that's fine, but the problem is he has to get to A, though. Right? The problem is A. How does he get to A? So, in an alternative facts, right? Some alternative facts. In an alternative, in a different hypothetical, had he just built the garage on B, and did he not ask the court to modify the easement? I don't see any problem. But that's not what happened here. He tried to have the court modify the easement. Right? And now let's see. Tyler, what was the argument that the plaintiff used of why the easement should be extended from B to C? What were his arguments? In a very, I think, intuitive, natural argument that most people say, like, duh, of course that's right.
That the extension of the use of the easement for the benefit of non-dominant property does not constitute a misuse of the easement.
Why? Why did he say there was no misuse? What was his? A very simple argument. It was a very elegant argument. Makes sense to me. You're his lawyer, right? You're his lawyer. What are you going to make in the case? What are you going to tell the court about why the easement should be extended to C? It's a very simple argument.
Because he's using the easement for the exact same purposes he was using before. There's no more or less traffic.
Yes, exactly. There's no burden, right? There is zero extra burden on the defendant by granting this extension of easement. There's no burden whatsoever. The same exact car that goes from B to C, if it starts a few feet over the line, it doesn't create any more traffic. It doesn't create any more garbage or any more pollution. There is no burden whatsoever at all on C. This isn't like saying, we want other people to cross the thing. It's just me. Now, Anna, is that right, though? Is it true that extending it from B to C won't have any additional burden, have any additional people traveling? Is that right?
I don't understand this at all, because he owns B and C, right?
Okay, good.
So why does he need an easement? He just needs to get to the edge of the property, right?
Well, but he wants apparently the driveway to run up to B to C. This is the question we raised before.
I just don't understand why he can't do whatever he wants once
This is why the question I posed at the outset. He just builds a garage on B and doesn't even try to change anything. That's not what he did. He's trying to get it. But to answer my question, I want you to answer my question, Anna. Is it right that because you said to C, there's no additional burden? Is that right?
I mean, I guess you have to go further,
Chester?
I think it goes back to what Lauren was saying. B and C are two different parcels. So
Oh, that's the right answer. So what could happen later?
So if you sell C,
Yes, exactly. That's exactly right. Right? Keep going.
well, I mean, you sell C, you don't know who's going to move.
So what if they get this easement extended, right? And then an apartment building is built on C. Oh. Then instead of having one person cross it, there are 30. So there's actually, it's simply not the case that this is painless, right? If the court does extend the easement over to C, it's not enough to say, oh, same person owns B and C, they're different parcels of land. And by putting an easement on A for the benefit of C, look how big this lot is, it's twice the size, right? They put an apartment building up there, or multi-family home. Not this very wealthy portion of Washington. In theory, right? They put a multi-family home with like 8 kids, right? All cars. There's a lot more traffic coming down the road.
why can't you just put an easement on B himself?
That's what who put things on B?
Like, he owns it.
He already has things on B. He doesn't need it. Again, this is the same question I asked Casey a minute ago. If they had just done this smart, the case would never happen. If they just said, we're putting our garage on B, we don't need any extension of easement, there would have been no dispute. He wanted it, 'cause I think there was some bad blood between the neighbors, which seems always to be the
So
case.
is the easement treated as a whole, even though it crosses both things?
The easement isn't exactly what the easement says. This is an easement for the owner of B to cross over A. That's all the easement says. It does not allow anything from C. What he wanted was basically rewrite the easement that says the owner of B and C can cross over A. That's what he wanted.
It's not about getting there, it's about easement.
Yeah, coming and going doesn't matter.
I don't understand this at all.
The plaintiff wanted a rewrite of the easement. Right? The plaintiff wanted a rewrite of the easement such that anyone can cross over. So that the easement, I'll write it up. Okay? So the easement started off like this. Okay? So the original easement, the owner of B can cross over A. Okay? That was the original easement. The new one would have been the owner of B and C can cross over A. That's what they wanted the new easement to be. Now, I think they could have just kept it like this, kept the original one. There's no problem. He could just keep his car or garage on B and no one would ever care. But by asking the court to extend the easement, that's where the trouble began. That makes sense?
I mean, my question. I mean, it seems to me that he was trying to gain an easement.
Oh, he
And
sure was.
Could he have not extended it?
He got
but
greedy.
Gained a new easement.
Well, he could have negotiated a second easement, right? Could have paid for it. But again, I think these neighbors hated each other. They came to blows, right? They were fighting.
Well, I think that was kind of my original question. Was if he had just gotten away with it for 10 years, crossing over A to get to his house on C, he would now have a prescriptive easement.
Well,
on C.
these guys started punching each other pretty quick. I don't think it would have made it 10 years.
Well, I mean, if they didn't know, if the person.
Well, no, he
if
knew.
They, if they didn't know he was driving across.
Look, I mean, look at the picture. He has to go right. Look, basically drive right in front of their house. I mean,
right, but he owns B. So if every day after 10 years he calls the court and says, "Hey, I've driven to lot
You're saying
C."
you're saying the other guy, the owner of A, wasn't aware of this C business.
Yeah.
Well, I think in the facts he was because he knew there was construction going on.
Yeah.
So, in other words, this is a small community, right? People know each other. If you see someone building a new lot, you may look into it. That's why I had someone else. Yeah, well,
I mean, back to the case, the defendant was first trying to stop the guy from moving stuff onto his property.
Yeah.
So then they were trying to get a legal, oh, well, you can't do this anymore because the easement extends. It's like, there was bad blood, and that was the whole point of that drawn out litigation for so long.
Yeah, I mean, this is again the reason why these disputes go to court. So the neighbors hate each other, and they waste all this money. They could have probably negotiated, a few $1,000s for an easement, and just not have to appeal to the state Supreme Court to get there. Yeah, Lauren.
with the argument of if you extend it to lot C and the traffic from the easement is increased, then that becomes a nuisance almost.
Well, no, it's not a nuisance if the easement's extended, right? If there in fact is an easement that says the owner of C can cross over to A, that's not a nuisance. The purpose of the easement is to allow that traffic
Right,
to occur.
that's what I'm saying. The argument was that they didn't want to extend it because if they extend it and something happens with C and more traffic comes in,
Right.
then that becomes a nuisance. But you can also build the same apartment complex, maybe not as big since lot C is bigger, but you can build an apartment complex on lot B as well, and the traffic extends as well.
So you're saying even if they built an apartment on B, it will go beyond the intent of the easement, right?
Right.
Okay, so that's a different argument, and that actually comes into the next case, which I'm not ready for yet. What happens if circumstances change, right? You have an easement for a railroad and you want to make it a nature trail. Or you have an easement for a single family home, and then you have an apartment complex with 100 people living there. Can the court update, I'll put that in scare quotes, right? Can the court update the easement to reflect circumstance, or it says, sorry, too much, you guys are trespassing? That's the next case. I'll get there in a couple minutes. I want to finish this case first. Anna, does this make sense?
Yeah, I don't know.
Okay, good. All right. So the decision here by the court is actually somewhat strange. It doesn't really. It doesn't make it up. I think I actually read the dissent here. I don't know. I usually do. So what the court does here is they say that we're not going to extend the easement, right? We're not going to say that there's any reason to extend the easement to C, right? But at the very end, they basically say, even though we hold that we're not going to extend the easement, we find that the lower court's injunction was not an abuse of discretion, so we affirm. So why this case is so strange, at least for me, is they say, no, the plaintiff is wrong on the law, but we'll give him an injunction anyway. Why? Okay, that's my question for you, right? They say the plaintiff is wrong on the law, but we'll let the injunction stand so the plaintiff can continue trespassing onto C, right? Michael, why do you think the court, I mean, they did it really quick, too. They had this entire thing about 11 pages, so they got it flipped in the other direction. What fact of the case do you think made the plaintiff give a victory here? There's a couple. He wasn't landlocked. The road is right here. But other than landlocked, what else is there? I think there's a reason. They mention it. Yeah, the improvements, right? Everyone see that. The guy spent $11,000 in improving the road and the property. Again, if you spend money on something, courts will probably rule in favor of you. This is like the case from, remember the case in Kentucky with the road, right? And remember there was a coal mine and the improvements were made on the coal mine road. If you spend money to improve a piece of property, you're probably going to win. It's a weird thing. Courts are very much concerned when parties spend money and then have to lose it. So at the very end, the court says, well, we agree the plaintiff shouldn't win the law, but as a matter of equity, the injunction should stand. Now, the effect of that was second Chester. The effect of that is, though, Jesse, what happens under this ruling if C tries to build an apartment complex on C? Will this sort of an equitable ruling stand?
That wasn't what was granted.
Okay, see that right there. The upshot, right, of this equitable ruling is its balancing test. And if C decides to push his luck and goes and builds an apartment complex, such that there's like 100 new people living there, I'm pretty sure this ruling will be reversed. Like, well, that's not what we had in mind. We're just one person, there's no burden. So it's a weird thing where he didn't get the easement he wanted. He, by himself, can cross over, but if there's a future owner of C with an apartment complex, out of luck. So, you know, win-lose, the effect in this case is probably not much. There's no real burden on A at all. But if that burden were to increase, there would be a loss. The dissent by Justice Doré, I don't know how to pronounce it, says, the majority's right. The law is not on the plaintiff's side. Then why did they go down this road? He also mentions a possible remedy, which is worth discussing, is eminent domain. And this is the power of the state to seize land in public use when you provide compensation. If indeed this property was landlocked, the state could have just taken a little bit of land over here, chopped it off, and made another road. Right? They didn't. I think I agree with the dissent. I don't know. The majority ruling is a little bit weird for me. It's like you're right, and the last one they spin around and say, never mind. We'll just issue this weird ninja rule. So, question, Jesse.
Is there anything we should take away from this case, or kind of just running?
The thing you take away is if you make improvements, you're probably going to win. If you erect a fence, you're going to lose. Right? As a matter of equity, and this is again a ruling in equity, if you're going to put money in a piece of land, you're probably going to win. If you go and build a fence with a cement rope, whatever else you put in, you're probably going to lose. But let me answer your question for real, right? The real lesson here is that courts aren't going to extend easements, right? Because that binds not just them, but future owners. Courts will limit easements to the terms that they're used. And here, the easement was from B to A, and that's the extent of the easement. They won't go from C. Robert?
So they said that it was a misuse of the easement, but there on 868 they talk about damages. So is that a general rule? They'll allow.
Well, what are the damages here?
There were none.
Yeah,
so,
basically $1.
So would they generally allow misuse of an easement as long as there's no provable damages?
Well, remember we discussed nuisance, right? The trespass and nuisance are actually similar. When you say that the damages are nominal, just $1. That is usually coupled with an injunction saying you can't do it anymore. So it says the fact that you've been driving over this land for however many months inflicts maybe $1 of damages. But what really counts is the injunctions. Here, the monetary damages are largely irrelevant. They don't really play any role here because they're, maybe some tire marks in the road. I mean, there's not much additional impact. David?
Yeah, I was just wondering what might happen if it doesn't happen yet, but B1 is about to sell C2. It's like a corporation that's going to build an apartment. Like what might a new apartment?
Under the ruling in this case?
Yeah, under the ruling.
Well, I think if C was sold to an apartment complex, A would go to court and ask to reconsider its injunction and saying it's no longer equitable. In that case, I mean, the apartment complex has to know they don't have a guaranteed easement. They only have this sort of equitable ruling that won't stay in effect forever. Jesse? Sorry, Chester, is that further? Yeah, go ahead. Yeah, go for it.
It's fair to say that courts won't extend easements unless it's necessary to prevent justice.
This is equity here, right? This is equity. And equity, the magic word is my favorite F word, which is fairness, right? If you got it because you set up a single family home and then you decide to sneak around and sell to an apartment complex, the spirit of equity, as they would say, probably does not come in your favor. Chester? Same? Yeah. Okay, Anna?
So, I guess if you had an easement for gross, this wouldn't have been an issue.
Well, an easement for gross.
To cross over A.
Yes. So if it was an easement in gross, he could cross over A from any direction. That's right. Now, Anna, what if the easement like this, right? Let's call him the plaintiff. I forgot his name. The plaintiff has an easement in gross to cross from B over A. Right? That's not a very useful easement in gross at all. Right? But if it's plaintiff has an easement in gross to cross over A to get to Main Road, something like that, right? That would be, I think, what you're asking about, right? The second one. Yeah, the first one would not be very useful easement in gross. Wouldn't get him any further. Sorry, what was your question? I just.
Technically, he would have never been able to cross A from C anyway. He had to go through B first, no matter what.
Well, you negotiate another easement, but he owns it himself, so it's not a problem.
But I'm saying, I mean, the easement starts at the B property line. Once he got to B, he was crossing B, right?
I don't know where he's going. This is why, again, and I think your question for Lauren was on point. B and C are separate lots. Even though they're owned by the same person, they're separate lots and they have different rights and privileges. This is why most of you got this question wrong at the outset. Right, when Betsy owns Whiteacre and Blackacre, they're still separate pieces of land. But by owning them together, the easement is extinguished, it terminates.
I guess my comment was because it was impossible for him to jump over B in order to get from A.
Pole vaulting? I don't know. Helicopter, right? Our favorite, Deus Ex Machina for law school, the helicopter example, right? Fly over. Okay. All right. So, I think someone asked before, what's your takeaway from the second case? Don't build a fence, and if you improve land, you're probably going to win. But I think the real lesson from this case is that courts are not going to redefine easements. They will limit them to the terms of the parties, and if there's some sort of problem, you guys can work it out separately. Okay. So any questions on the second case?
So you think the main reason why they actually extended the easement?
They didn't extend it. They did not extend the easement. Be very careful. It says a matter of equity will issue an injunction, but that's not something that goes in the record office, right? Okay. That's not an actual stain on the title.
So A wasn't.
It's a court injunction that requires the owner of A to allow the owner of B and C to cross, but it's not an easement. They did not extend the easement. Be very careful about that.
So if A sells, that land isn't burdened by an easement to C?
If A sells the land, I think the person who buys from is now subject to that injunction. Okay. But that injunction is not permanent. The court could reverse it later if an apartment complex is built, for example.
Okay. But you think the main reason why they actually issued their equitable ruling was because he made improvements?
Made improvements, the other guy built a fence. I've been reading these cases for some time now. If you build a spike, it's called a spike fence, right? You build out a spike. If you build a spike fence, you're going to lose. Judges do not like that. Judges don't like self-help, right? I guess you did this in torts, right? Self-help. Do judges like self-help? No. They do not like self-help. There's one case in Property 1 you might remember where there was a tenant at a restaurant, and the restaurant goes into business, and then the landlord thinks that the tenants start stealing, stripping out the walls and all the furniture. And there's one case where the guy's hanging on an awning. Do you remember this case? Basically, the landlord tries to change locks. He comes in the morning with the sheriff and tries to change the locks on the tenant who's not paying his rent. You know how that case is going to turn out. They rule against the guy who tried to change the locks. So if you have a case where someone's engaging in self-help, they're probably going to lose the case. It's, I don't know why the spirit of equity, but in every case I read, that's usually how it turns out. That's why I call it the F word, because it doesn't really make sense. At least to me. All right, any other questions on the second case? The third case, the Persalt case, is a little bit weird. It probably doesn't fit in. Like, why is Blackman giving us this weird case to read? Well, the reason why I give it is actually not so much for the discussion on takings. You'll do the Fifth Amendment later, right? But the general idea is, if the government wants to use your property, they have to pay you for it. If the government wants to take your property for some public use, they got to pay you for it. What happened here is that some genius person in the government said, wait a minute, we have all these old railroads, right? We can just give the land to local states and counties. They can make parks out of it, make trails. It's genius, right? Well, what they didn't consider is not all the land that's owned by the railroads are still owned by the railroads. And some of them may now be owned by private citizens. Or perhaps some of the easements the railroad had didn't extend to nature trails. Right? So that was the nature of this case. But I want to give you a law school classic. Right? This is a question that law students for thousands of years. No, not that many people, decades. But you know, it's the same concept I've been asked, right? So you go up to a park, and the sign says "No vehicles in the park." I actually found such a sign. I was at Golden Gate Park in San Francisco, and the sign says here, it's hard to read, it says, "No vehicles in the park." Now, what you don't see this guy up here? He was on a bicycle. And what you don't see is he was coming down that steep hill really fast. So about a second after I took this picture, I almost got run over. It was actually really close. Because I'm standing right here between the between the poles, and this guy on the bike was probably going 30 miles an hour flying down this hill. So it was a scary moment. I didn't get a video. I was like, oh cool, click, crap, and I had to run out of the way. And I lived to tell about it. So you see a sign says, "No vehicles in the park." Okay, who am I up to? Caitlin, no vehicles in the park. What does that mean?
Well, I mean, I guess if you want to be technical, you have to ask them what they define a vehicle as.
Okay, I'm asking you.
Something with wheels that move.
Okay, wheels that move.
Bike counts.
Okay, so what about a bicycle?
Maybe.
Okay, why you say maybe?
I mean, it depends on why they don't want vehicles there. If they don't want vehicles there for like the wear and tear, then I think a bike would count.
So no bikes allowed. Dave, what does that mean? No vehicles in the park.
I would think it's like more like cars or SUVs or
Well, why is a car different than a bicycle? Why would a car be a vehicle but not a bike?
because a bike is for recreational use.
People get around the bike. Maybe people use it for get to work, whatever. So why is a car different then? Okay, so you're saying the purpose. So a bike is recreational, where the car is not. What about you mentioned an ATV, right? What about a Segway? It's stupid things, right? I'm sorry, I don't like that. What a motorcycle. People ride those for fun. Ride a Harley in the park. Travis, my friend, what is no vehicles in the park? What does this mean to you? How would you understand this? You're walking in. I mean, how do you understand this sign? Motorized. How do you now? Where do you get motorized from? So you look at how it's used, right? Like tradition and how practice, right? Okay. Well, what do you see for no vehicles in the park? How do you understand that sign?
Well, in Texas.
Texas, oh, God bless Texas, my favorite state. Every time I leave, I'm happy when I come back. I was in, where was I yesterday? I was in Indiana. I'm always happy to come back.
Texas, the bicycle is considered a vehicle by state statute.
Is it? Oh, how do you know that?
So as an avid cyclist.
Oh.
to run off the road, it's like, no.
I'm a vehicle too.
Yeah.
So you'll look to other statutes, right? Now, do you know when that statute was written that makes a bicycle vehicle?
Probably in the 70s.
Okay, 1970s, right?
Right.
What if I told you that this sign's been there since the 1920s? It's an old sign. It's old, it's dusty, but it's an old sign. It's been there for, say, 100 years.
Well, I don't know. Now, now it would be any vehicle. So whatever you're going to define as a vehicle.
Okay. So if you're saying, let me ask you the question differently. What if this sign was written in the year 1875? This is an old sign. I mean, like, it's an old sign that's really good. It's a strong sign painted in stone, right? Sign was painted in 1875 with no vehicles in the park. How would you understand that? It's a public park. So could you bring a bicycle in if it was 1870s? Remember the big wheels in the front? You've seen those, right? Why not? Okay. Mia, what about a baby carriage? What a baby carriage.
I don't
Stroller. I think Caitlin said it has wheels and carries somewhere. Why is I think her answer is good. Why is a baby carriage not a vehicle? It's used to carry a person's wheels. Spins her out.
I feel like the sign is more for safety, like
cars and motorcycles and that stuff goes faster. Like you can't go 30 miles an hour in a baby.
I don't know. The people who jog, you know, those 3 they go pretty fast with them running through the trail, right? Taylor, how do they understand there's no vehicles in the park business?
I think it has to go with why they created the park and
Why they created the park? What do you mean by that?
like the intent of what the park is for.
How do we know what the intent of the park was for? This was created 100 years ago. It's an old park.
Well, we know the intent is not that big.
Well, but no. Well, but now you're circling, right? How do you know what the intent of the park was?
The original agreement when they.
There's no paper. It was 100 years ago. Some guys mowed some grass and that was it. They made a park. Emma, what about a horse? Could you ride a horse in a park?
You can transport yourself with a horse. So
Is a horse a vehicle?
It could be a vehicle.
So could you ride a horse in the park?
Well, like you were saying, if it had been enacted like 100 years ago, probably not, because back then there was a lot of traffic on horses, and horses were used more.
But you think today you could use a horse?
Today, I think it's still.
How do you update a sign? The sign was, I said it was etched in stone. That's what I told you, right? The sign was written in stone. How can you today, Emma, what gives you the right to update the stone that's been there for 100 years? Doesn't the sign have the same meaning today as it did 100 years ago? How does a text in stone, literally chiseled in stone, have a changed meaning?
Well, culture and society changes, but.
How can a judge update a statute or a sign written 100 years ago? I don't know. How do they do that?
I don't know.
Bradley, help me out. Can you bring a horse into this park?
I think based on the no vehicles allowed, it's sketchy because it's a hybrid between the wear and tear that Caitlin's talking about, the safety that all these people are talking about. I think it's a hybrid in that the intent is not to have Granny's motorized scooter not allowed, right? That wouldn't be considered no vehicles allowed, but maybe a horse would be considered a vehicle because of the wear and tear and stuff that horses do, and you know that type of thing. So, I don't think it's just as simple as safety or it's transportation.
Yeah, but you're giving me lots of good stuff there, Bradley, but how do you know any of this stuff is true? All I've given you is a sign. I didn't give you much else. How do you know any of these things? I mean,
well, none of us know any of this.
Right. So how is anyone supposed to know what this sign means?
Because of common practice.
Common practice. Alex, help me out here. Where do we get this practice from? How do we? I mean, do we have like a history of the park? Do we look at a whole? If there's a photograph of some guy on a horse in there from 80 years ago? I mean, how do we even know what this practice is?
Oh, the question is, how do we know what the practice is?
Yeah.
Just watch them.
Well, what happens if one guy came in a horse and he got yelled at, and no one came in a horse after that?
Then no one would go on horse after that.
Okay, and what if some guy came in a horse every night when no one's paying attention?
Nobody would care.
One at a time, please. One at a time. One at a time. We're having fun here. I always have fun, but you know, this is special. Alex, I mean, but how do we define practices? Like, how many baby carriages have to go through there before that becomes the rule? I mean, a Segway is brand new, 10, 15 years old. Is that allowed? If there's been 100 years of practice and only Segway for a couple of years, does that change the meaning of the sign? What if, Valerie, cars didn't exist in the 1870s in the example I gave. Could the framers of this sign, right, have conceivably known what a car was, or what a Segway scooter was, or I don't know what the hell those little zip scooter things people have, right? So, do we limit it to only the vehicles in existence in the 1870s?
No. Well, I mean, the way I thought about it was.
Oh, that's my question. No.
Well, no, you don't.
You don't. You can add new vehicles, right? Is what you're saying? How do you know that? What if they said we are only concerned with vehicles that exist in the 1870s? We don't care about what newfangled vehicles are made in the future.
If the sign said that?
I don't know. Maybe it does. All the sign says is no vehicle. It's all it says. 3 words.
That's what it says.
But isn't one way of understanding it that we just limit it to whatever vehicles are in existence now, and we don't worry about later? Why is that, Jesse? Keep raising your hand. What do you?
That's why if it's public, wouldn't you look at the state legislature?
There's no legislation. There's just a sign. The sign was put up in 1875. But Phil, if if this sign is so perplexing that 30 of you can't even figure out what the hell it means, what's the right answer? No, not that's how you get arrested for trespassing. So Philip, that's actually a question for Philip. What should be done if this sign is so annoying and confusing?
I don't know, have like a public forum or something.
And then after the public forum, what do they put up?
I'm more specific.
Yes! Right? Okay, this took what, 20 people? Good. Thank you. So, I think what all of you are getting at is you see these signs, right? It says, no cars on the road, right? You see these signs, right? No motorized vehicles. Now, the sign said no motorized vehicles in the park. Oh, right. You could figure out what that means.
Wheelchair.
Well, is a motorized wheelchair a vehicle?
Well, yeah, that's the question.
There's actually a case a couple years ago where a guy was given a DUI on a golf cart. You know the little golf carts? He was driving under the influence on a golf cart. So, and the court actually held that was a vehicle. The court held that a golf cart was a vehicle for purposes of the DUI statute. But anyway, I gotta move on. But you see what I'm getting at here, right? This is not just about easements. This is a general lesson in interpreting any text. And all of you, willingly or probably unwillingly, seize on different ways that you want to interpret a text, right? You can say, what was the purpose of it? Right? Was it about safety? Was it about preventing traffic? But how do you know what the purpose is? There's not often legislative history. Some of you said, well, let's look at common sense, right? You don't want a car in a crowded park. Well, how do you know what common sense is? Maybe this was a park made for, demolition derby. I don't know, right? Some of you asked about horses. Do we limit our interpretation to what was known at the time the statute was framed? Or do we say that they wrote it with the understanding that new things will come around and those should fit into the framework, right? Some of you said, well, let's look for legislation, right? Let's look for a statute. You don't always have that. And often the statute may simply say no vehicles in the park, and then where do you go from there? But the bottom line is, right, the bottom line is this. If a statute is not clear, or a sign is not clear, why does it necessarily fall to a judge to update it? Right? Why can't we do Philip's plan and just have a town meeting, form, and put up a new sign? All too often, the answer in law school is, well, if the statute's not clear, let judges rewrite it, which I strongly encourage you to consider as the wrong answer. And in fact, in the Persol case, that's exactly what the court holds, right? They hold that an easement made, 100-something years ago for railroad, right, that was the purpose of the easement, for railroad usage, does not lend itself to an easement for hiking and walking in the woods, right? That, of course, it's a lovely thing to have a nice park, right, by the lake that you can walk along, but the easements in those cases were not for that purpose. So the Persol case is actually somewhat unique, right, in that the judges were not simply willing to rewrite an old easement. Now, consider this in the statutory context, or even the constitutional context, right? You have an old constitution, it's, it's on pocket. 200, I don't have it in this jacket. When I go to the dry cleaners, I usually bring it with me. Anyway, I have mine. I always carry a spare, because I never know when I'm going to need it. Please. Okay, so you have an old constitution, 200 years old, right? Or in the heart. In this pocket, not that one. You have a pocket in this one. Usually there's only a pocket on this side. But you have a constitution, it's 200 years old. Do we interpret it based on some sort of purpose and what the framers had in mind? Do we interpret it based on what our common sense of today is? Or do we say this is an antiquated sign, we just update it? They didn't know about Segway scooters, we have to update it for that purpose. Or do we say if it's so antiquated, let the people change it through an amendment, right? The reason why this example, this no vehicles in the park, is, or should be taught to all law students, doesn't always happen, but I always do in this spot, is precisely for this effect, right? How do we interpret an old text that doesn't necessarily fit into our way of life? And the Persol case, which says basically we're not going to update an easement, represents, I think, a good illustration of this dynamic. Okay, so questions? Jesse?
Well, that's moving forward. Wouldn't you look at a state statutory definition of what a vehicle is?
Yeah, that was what William said, and I told you this sign was created before that statute was enacted.
but wouldn't you look at currently, like whatever time the litigation is?
But that wasn't the intent of the framers, though, right? The people who wrote that sign came 50 years before the statute. Maybe they had different conceptions about a bicycle. How can you import a modern day understanding of vehicle back on people 100 years ago? What gives you the right to do that? Shouldn't we try and figure out what they thought a vehicle was, not what it is today?
Wouldn't you look at it as the responsibility of the park to get that information, not the responsibility
But they
of
can make a new
someone
sign.
else to design?
What if they now, if the sign was updated in 2017, then we'd incorporate this definition. My question was precisely, we don't do that. It's an old sign, it's chiseled in stone. And the better question is, could a cop arrest you for riding a bike in the park? Right? This guy's saying, no way, right? No way. Could a cop arrest you for riding a horse in Herman Park, right? You know, could a cop arrest you for bringing a Segway scooter or a motorized wheelchair, right? These cases get litigated. I mentioned there was actually a case where a guy was cited for drunk driving on a golf cart. And the actual nature of the case was the golf cart a vehicle, right? There was another case from another state where a guy was driving drunk on his own property. I think in like one of those little ATV things. And they said, well, it's not a vehicle because it's on the property. But these sorts of questions arise again and again. So any question, Bradley?
Takeaway from Prasad is basically whatever the easement was for, that's what it's for?
That's what it's for. It's not for the courts to update.
And if the government wants your easement, they have to pay for it?
Exactly. We'll do takings later. I'll come back to this later. But the holding of Prasad is we're not going to update the easement for you. If you want a new easement to cover nature trails, pay for it. Right? What no vehicles meant in the park in the 1890s is what it means today. What railroad easement meant in the 1890s is what it means today. And a railroad is not a hiking. Right? Because imagine, if you say no vehicles in the park meant transportation, right? You can't have modes of transportation. Then Prasad would have lost. If the case was simply a railroad is a means of transportation, hiking is a means of transportation, it's all together. The court said no. Railroad is railroad, hiking is hiking. And they're different things. So if a sign said no railroads in the park, or actually, railroads are allowed in the park, right? The sign said railroads are allowed in the park. Could you bring a bicycle? No. Because a bicycle is not a railroad. Questions? All right. Good luck studying for the weekend. Your exam's on Tuesday. Ali will be back on Thursday.